name is Norfatin Syuhada binti Mak Rahim. I am from DLS 3B. My number metric card 30DLS19F1059. I study at Polytechnic Metro Johor Bahru under course Diploma Logistic and Supply Chain Management. This video for subject Business Law by Madam Fatimah Zahra. I am Amin, plaintiff in the case between Shah and Amin.
Hi, Assalamualaikum. My name is Mariam Saparin. I study at Polytechnic Metro Johor Bahru in course Diploma Logistic and Supply Chain Management. I'm from class DLS 3B. My metric number is 30DLS 90F1005. I'm the subject Business Law by Madam Fatimah Zahra. I'm a Shah defendant in the case between Amin and Shah. Stay tuned. Today, 25 November 2020, the case confirmed between Amin and Shah will begin. This case is Amin, who runs a lorry transport service, was instructed by Shah to deliver some watermelon from Terminal Pahang to Kuala Lumpur. During the journey, one of the tires burst. As a result, the lorry was skidded and hit a tree. Some of watermelons were damaged. Amin sold them at a very low price to passersby. The remaining watermelon which were not damaged will load onto his friend lorry and transport to Kuala Lumpur, advised him. In this case of both, can you submitting what you want to present?
I am Norfatin Syuhada binti Mak Rahim as an agent to plaintiff named Amin. Here, I would like to take this case to compensation to the defendant. This case about agent can claim by necessity, where the agent to claim his salary of selling the watermelon. In this case, the defendant ordered the plaintiff to send the watermelon by lorry. However, the lorry crashed and caused some watermelon to be damaged.
Is the issue to claim between plaintiff and defendant a law as in duties and agent to principal or duties and principal to agent?
Whether Amin can sue Shah to claim his salary of selling the watermelon. Amin can claim to be an agent by necessity with the condition that Amin fulfills all the conditions to be an agent necessity. Under Section 142 of the Contract Act 1950, an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as will be done by a person of ordinary prudence in his own case under similar circumstances. Based on Section 142, Amin has authority in an emergency when the lorry was skidded and hit a tree. Some of watermelon were damaged. Amin sold them at a very low price for the purpose of protecting the principal from loss as will be done by a person of ordinary prudence in his own case under circumstances. Based the case of Springer vs. Great Western Railway. Court the defendant agreed to carry the plaintiff tomato from Jersey to Covent Garden Market. Owing to bad weather, the ship arrived late at Weymouth Minshall. The defendant workers were on strike. Therefore, the tomatoes were found to be in bad condition. The defendant decided to sell the tomatoes at Weymouth because the defendant felt that the tomatoes could not arrive at Covent Garden Market in sellable condition. Plaintiff claims for damage. Here, the plaintiff was entitled to damage because this defendant were not agent by necessity because they have failed to communicate with the plaintiff when they could have done so. Relate to our case Springer vs Great Western Railway, Amin sent watermelon directed by Shah from Temelloh Pahang to Kuala Lumpur by lorry. They were contracted to carry, not sell. However, the lorry's tires broke, causing the lorry to slip and hit a tree, causing some watermelons to be damaged. Therefore, Amin decided to sell the fruit at a cheap price without Shah knowledge. To give them the right to sell, there must be a situation that suits their position as a necessity agent for the owner.
May it please the court, my name is Marini binti Saparin, SN Principal to defend name Shah. I'm here is to defend my client in this case. This is because the plaintiff violate defendant which duties an agent to principal. Shah can blame Amin because the agent has sold the watermelon at very low price. Based on section 164 of the contract at 1915, an agent is bound to conduct the business of his principal according to the direction given by the principal or in the absence of such direction, according to the custom which prevails in doing business of the same kind at the place where the agent conduct the business. When the agent actually authorizes, if any loss be so sustained, he must make it good to his principal, and if any profit accrues, he must account for it. Based on section 164, Amin is bound to run the Shah business because it must follow the principal's instruction. If his principal does not give any instruction, the agent cannot run the business at will. When Amin actually the other ways around, in the event of a continuous loss, he must do good for his principal, and if there is a gain, it must also be explained to the principal. Then, prove an example of a case that can further strengthen the evidence. Example case is Turpin vs Bilton. The agent has been instructed by the principal to get insurance for his vessel. However, the agent failed to do so. The vessel lost, and as a result, the principal has to bear some loss. Hence, the agent is liable for breach of duty due his failure to obey the principal's instruction. The agent is liable to compensation for the loss. Leading to our case of Turpin v. Britain 1843, Amin was instructed by Shah not to sell damaged watermelon was sold at a cheap price, and as a result, Shah had to bear the loss.
As a conclusion, Amin can claim to be an agent by necessity with the condition that Amin fulfills all the conditions to be an agent necessity. Based on section 142, Amin has authority. In an emergency, when the lorry was skidded and hit a tree, some of watermelon were damaged. Amin sold them at a very low price for the purpose for protecting the principal from loss, as would be done by a person of ordinary prudence in his own case under circumstances. Relate to our case, Springer v. Great Western Railway, Amin sent watermelon directed by Shah from Temelloh Pahang to Kuala Lumpur by lorry. They were contracted to carry, not sell. However, the lorry tires broke, causing the lorry to slip and hit a tree, causing some watermelon to be damaged. Therefore, Amin decided to sell the fruit at a cheap price without Shah knowledge. To give them the right to sell, there must be a situation that suit their position as a necessity agent for the owner.
As a conclusion, Shah can blame Amin because the agent has sold the watermelon at a very low price. Based on Section 164, Amin is bound to run the Shah business because it must follow the principal instruction. If the principal does not give any instruction, the agent cannot run the business at will. When Amin acts the other way around, in the event of a continued loss, he must do good for his principal, and if that agent is must also be an related to our case of Turpin vs. Bilton 1843, Amin was instructed by Shah not to sell damaged watermelons. But Amin failed to do so. The watermelon was sold at a cheap price, and as a result, Shah too had back to the loss.
I hope that the court can be able to make a fair decision based on the evidence that have been presented with the firm that has been given.
For the foregoing reason, I respectfully request that the court find in favor of defendant and must behave fairly so that the defendant is entitled to duties as an agent to principals. Well, I will consider the motion and voice that have been explained that proved by the plaintiff and defendant.